Okay, here we go. Rules Committee come to order, and thank you very much for joining us this afternoon. Our two witnesses who are here, Mr. Conley, you're a regular up here. Mr. Comer, we normally and will fill in the room here in just a few minutes. During the middle of the day when you do these things, there's a lot of competition. So thank you for taking time to join us. Today, the committee will be considering H.R. 4182, ensuring a Qualified Civil Service Act of 2017, as well as H.R. 1169, preserving access to Manufactured Housing Act of 2017. Many positions within the federal government require a one-year probationary period. This time provides individuals with an opportunity to learn on the job and undergo proper assessment before becoming a career employee. Probably also offers the government a chance to make that same evaluation. H.R. 4182 extends the probationary period to 2 years, ensuring agencies have enough time to assess the performance of a new employee and managers before making a final appointment. By increasing the probationary period to 2 years, it allows employers and employees a chance to work together to receive common feedback and about their performance, and to enable them to ample opportunity, if I could speak today, to improve their performance over a period of time. This committee will also consider preserving access to Manufactured Housing Act of 2017. This legislation ensures that consumers of small business mortgages have access to mortgage credit for the purchase of manufactured homes. Manufactured housing serves as an affordable and sustainable housing option for roughly 22 million Americans. Regulatory red tape in Washington should not keep people from purchasing these homes or any home of their choice. This bipartisan bill is a narrowly focused effort to help Americans achieve a greater level of financial independence by being able to offer a manufactured home for them and their families. So without objection, I would like to welcome both the gentleman from Kentucky, Mr. Comer, as well as the gentleman from Virginia, Congressman Conley, to the first panel. And without objection, anything you brought in writing, we'd like to ask that you leave it for our awesome stenographer so that she can properly complete the record with the proper transcript. And we're delighted to have you here at the Rules Committee. Before I pass on to you, asking you to open, Mr. Comer, I'd like to yield to the gentleman, the ranking member, for any opening statement you choose to make. Gentleman's recognized.
Well, thank you both for being here. I look forward to your testimony, and I have nothing else to say right now, so I'll yield back.
Thank you very much. We are in the middle of the day, and members will be coming in and out, but I will tell you that what you're talking about today is an essence of good governance. It's an essence of good management, and it's an essence of Congress understanding how and what the rules and regulations should be for those government employees. Too many times we find that employees of the federal government go sometimes without compensation, but I think many times without a real pat on the back for the public service that they perform, for the things which they engage in on behalf of the American people. And I'm delighted that you're both here to talk about this issue. And Mr. Comer, you're now recognized.
Well, thank you, Chairman Sessions and members of the committee. Thank you for holding this hearing on a structured rule for the consideration of H.R. 4182, the Ensuring a Qualified Civil Service Act, or the Equals Act. I introduced the Equals Act with my colleagues, Representative Meadows, Heiss, and Loudermilk, to ensure the federal government can obtain the talent it needs to complete its important functions. From Social Security claims adjusters to contracting specialists, federal jobs are increasingly complex. Extensive training and specific skill sets are necessary to fulfill the duties of these mission-critical jobs. Federal managers need time to determine if new hires are the right fit. And new hires need time to learn the requirements of the job and to demonstrate that they are a good long-term fit. To allow agencies and employees time to do that, most new hires in the competitive service serve a one-year probationary period before full employment status is granted. But a one-year trial period does not align with the realities of many federal jobs. The trial period needs to be adjusted to account for the increasing complexity of federal jobs. For instance, many positions require formal training before new hires can begin working. This prevents supervisors from evaluating the new hire's performance until the end of the training. Yet, even though supervisors cannot use training time to evaluate employees' job performance, it still counts against the probationary period. For some positions, the training period is 1 month or less. However, in other cases, the training period can last a year or longer. This means that a federal job with extensive training, by the time a probationary employee completes the training, the supervisor often has little or no time to evaluate the employee's performance on the job. The clock expires as soon as or soon after the prospective employee finishes training. The less time a prospective employee has on the job before the end of the probationary period, the less time that employee has to show he or she can do the job. Under a 1-year probationary period, managers often have almost no time to assess the new employee's abilities. Likewise, the probationary employee does not have time to improve based on the manager's feedback. What is a manager supposed to do in this case? Does the supervisor take a gamble and offer permanent status to an untested employee or risk missing out on a potentially skilled employee? This is a real dilemma. Supervisors throughout the federal workforce have described this exact scenario in their advocacy for this bill. According to the Government's Managers Coalition, managers tend to go off borderline probationary employees. Managers tend to let go of borderline probationary employees who, if given more time, might become valuable civil servants. Managers would rather not risk hiring an employee who they are not sure about because of how difficult it is to fire a permanent employee for poor performance or misconduct. According to the GAO, the procedural hurdles to firing poor performers can take 6 months to a year. The GAO also reported that supervisors often do not have enough time to adequately assess a prospective employee's performance before the probationary period ends. Chief Human Capital officers throughout the federal government say that an extension of the probationary period would provide supervisors more time to assess candidates for complex or difficult to assess posts. The evidence is clear. A 1-year probationary period is insufficient. We need to move forward a time frame better suited for today's federal jobs. The Equals Act does that by extending the probationary period for new appointments in the competitive service and initial appointments of managers to 2 years. Also, the Equals Act delays the probationary period until after required training and licenses are complete. To keep it fair, the Equals Act also extends the probationary period for new appointments in the senior executive service to 2 years. The bill would also address another point by GAO, that extending the probationary period will not do any good if supervisors do not make use of the extra time. GAO found supervisors are often unaware when the probationary period is ending. The Equals Act requires agencies to notify supervisors before the probationary period concludes. It also requires supervisors to certify that an employee has successfully completed the probationary period. This ensures supervisors are carefully assessing their employees' performance and taking the time to provide feedback to their employees. In closing, I would like to address a concern raised when the Oversight and Government Reform Committee considered this bill during a markup. Probationary employees have important due process protections during the probationary period. The Equals Act does not remove or change any due process rights for probationary periods. Probationary employees have access to the Equal Employment Opportunity Commission, the Merit Systems Protection Board, and the Office of Special Counsel. That will not change when H.R. 4182 becomes law. Congress extended the Defense Department's probationary period to 2 years in 2015. It is working well there, and we should extend it to the rest of government. I encourage my colleagues to support this good government, good management legislation that will ensure the American people are served by a professional and skilled civil service. Thank you.
Comer, thank you very much. Jerry, welcome. I'm glad to see you. Hope you're better today.
Thank you, Mr. Chairman.
Is that green button on there?
Yes, thank you.
Thank you.
Thank you, Mr. Chairman. Thank you to members of the committee. I appreciate the opportunity to testify on H.R. 4182, and I certainly appreciate my colleague from Kentucky and his commitment to trying to make the federal service more efficient and more productive. Unfortunately, from our point of view, this bill potentially chips away at the federal service by increasing the probationary period for career civil service and those in the senior executive service from 1 to 2 years. During the probationary period, federal employees have very little due process or appeal rights if disciplinary action is taken. They may be fired without notice, they have limited rights to attorneys or representatives, and they generally may not appeal their removal during the probationary period. Due process protections are critical to ensuring the integrity of the federal civil service. Those protections help prevent the politicization of the workforce and protect whistleblowers from retaliation, which the Oversight and Government Reform Committee has documented as a very real danger. The ensuring of a Qualified Civil Service Act is a solution in search of a problem. The Oversight and Government Reform Committee has not held a single hearing to determine whether extending the probationary period an additional year for every single federal job in the competitive and senior executive service is something that agencies need to help them better manage their workforce or desire. Not one hearing. In February of 2016, the Government Accountability Office issued a report at the request of the chairman of the Senate Committee on Homeland Security and Governmental Affairs. The request asked GAO to examine the rules and trends relating to the review and dismissal of employees for poor performance. Supporters of the legislation are using this report as a basis for extending the probationary period for federal civil service employees. However, nothing in this report calls for doing so. In fact, the title of the report is Improved Supervision and Better Use of Probationary Periods Are Needed to Address Employee Performance. It's not the same as saying, let's double it. What they're saying is, let's use the probationary periods that prevail in most federal agencies in a better way, with more supervision and oversight. In conducting this study, GAO found that supervisors do not always have the skills necessary to identify and help address employee performance issues. GAO also found that supervisors sometimes do not use the probationary period to make performance-related decisions about an employee's ability to do his or her job, and may not always know when the probationary period is even ending. The report's recommendations were mainly focused on ensuring that qualified supervisors have the training and skills needed to deal with poor performance and making better use of the existing probation period for new employees. Instead of focusing on addressing the gaps identified by GAO and encouraging agencies to implement the recommendations made in the report, Congress is attacking federal employees and the merit-based system. Under this bill, all new employees are punished equally, and supervisors are given no new tools to improve their use of existing probationary period. Within the report's recommendations, GAO does suggest that the Office of Personnel Management look into whether there are certain occupations, due to the nature or complexity of the position, as my friend from Kentucky indicated, in which the probationary period should be extended beyond 1 year to provide supervisors with sufficient time to assess a person's performance. The report says that's something that should be looked into. It does not call for a sweeping government-wide extension of the probationary period without examination, review, analytics, and data. That's why I filed an amendment, and I hope, Mr. Chairman, this one you'll approve, to give us a chance to debate this on the floor, to require the GAO to conduct a study on the experience at the Department of Defense and other federal agencies that have lengthened employee probationary periods. A 2-year probationary period for DoD civilian employees was enacted in the fiscal 2016 National Defense Authorization Act. As the largest federal agency, this extension of the probationary period would provide an excellent case study on the potential impacts of the legislation before us. GAO would evaluate whether extending the probationary period had any impact on the agency's ability to deal with underperforming employees and improve productivity. The study would also look into whether extending the probationary period has any effect on an agency's ability to recruit and retain employees, something that concerns me. I worked in the private sector for 20 years. I don't remember a company having a 2-year probationary period before somebody was formally hired into their position. It's important to study the impact of extending the probationary period for federal civil servants at DOD before extending this policy government-wide. Let's gather the facts. How did it work? Gathering the data is necessary first step for deciding the law, especially since such changes could have damaging effects, unintended damaging effects, on civil service protections and whistleblower disclosures. This legislation may ultimately prove to be a good idea, but right now, we don't know. There remains a lot of questions about the efficacy of this proposal. I'm concerned about the bill's potential impact on recruiting the workforce of the future. Currently, 40% of the current federal workforce is either eligible for retirement or soon will be. 40%. Federal agencies need to be able to recruit their replacements and get the requisite skill sets we need for many of these challenging jobs. Extending the probationary period to 2 years government-wide creates a climate of more uncertainty, not less protection, and diminishes the attraction of federal service overall for millennials. 2 weeks ago, Congress passed legislation that would pave the way toward evidence-based policymaking. We all committed to making policy that's evidence-based. For the sake of consistency, before we adopt this bill, why not see where the evidence leads us? If it leads us in the direction suggested in the bill, then terrific, we'll do it. But I would respectfully suggest we don't know that now because we haven't had hearings and we haven't had the GAO do a definitive study on what are the results, good, bad, and ugly, at the Department of Defense, which has, in fact, piloted this program. So I urge the committee to adopt an open rule for H.R. 4182. If you have a structured rule instead, I certainly urge you to approve my amendment for consideration on the floor, which would incorporate what I have just said. I thank you for your time, and I thank my friend from Kentucky for his collegiality.
Mr. Connolly, thank you so much. Mr. Gomer, I'm not an expert at all on facts of the case of the intricacies of federal employment. I've been involved for 20 years in the House of Representatives, 16 years in the private sector. But I do know that the government has many people that they employ who they try and make sure are a good fit for an organization. There are demands of the federal government back and forth, where it might be Homeland Security, it might be the FBI, it might be a lot of people who have things what I would call outside of the 8 to 5 realm. We have people who come into contact with government who think they want the job and sometimes find out it's a mismatch. Generally speaking, is every employee or are agencies advised to give at the end of a year, an evaluation to an employee under today's world?
The majority of the people that I've talked to oftentimes say that, 1 year's not enough time for a probationary period. A lot of times they don't realize when the anniversary is. I think from a standpoint of making the process better, I think this bill will certainly do that. Before I came to Washington, I was Commissioner of Agriculture in Kentucky. We had 300 government employees.
Yes, sir.
And the biggest complaint that I had from my managers was the fact that, there would be an occasional bad actor, and it was very difficult to terminate that employee for poor performance or for whatever reason. This simply gives managers more time. I think it would also be fair for employees to have more rapport with managers, knowing that they're going to be triggered when that anniversary is approaching. The 2-year probationary period is about to conclude. I think it's a better process. And I've spoken with many people in different cabinets of federal government that feel like this is a very good, very needed piece of legislation.
Mr. Conley?
I think you put your finger on a very important issue, Mr. Chairman. The GAO report, I think, really highlights the fact that whatever the probationary period of time, managers don't consistently across the board do a good job using that time to evaluate that employee.
Right.
So making it 2 years or 10 doesn't change that. And so I would argue that a better focus is training for managers so they do take advantage of that time in evaluating employees. And then I would respectfully repeat the point I made. It's going to be hard enough to recruit the workforce of the future for the federal government. I really don't know of a lot of companies when they're hiring new employees who say, and by the way, you're on probation for 2 years, and we can dismiss you at will. Companies I've worked for, generally, there's a 6-month grace period where we're evaluating your performance. But 2 years is a long time. And I feel it could have the unintended effect of discouraging recruitment for the workforce of the future, especially among millennials.
Well, I don't intend to consume a lot of time here. We did, Mr. Comer.
Yeah, Mr. Chairman, I want to clarify something. The way the law is now, the reviews are required semi-annually. Agencies can choose to conduct, to require reviews more often. So I just wanted to
See, this would be the point, Mr. Comer, and I think, Mr. Conley, with great respect, I've spent a lot of time with employees in technical fields, some of them, and I viewed that feedback from a manager is critical. I also viewed that feedback allowing an employee a long enough time to learn their job, not just you get here at whatever time and you leave whatever time, but actually in the performance of that job. That's, many of these jobs are so dynamic that it really does take time before an employee gets it down. And I think that the study that we know that took place over 13, 14, and 15 said majority of the people who were dismissed in the first year. In other words, if you made the first year, then you were probably a pretty good employee. I would hope this is only a benefit to a manager and an employee. And I think you're trying to sell that, Mr. Comer. You're trying to say, you know, it sometimes takes a little bit of time. This person might be in training, especially in many law enforcement and in technical areas. They might be gone for 7 or 8, 9 months. They might be in transition TDY somewhere else.
Chairman,
I hope we require and in no way get away from feedback from the employer and from the employee. Yes, sir.
I'm sorry, I didn't mean to interrupt. I take your point, and I think I cited that in my testimony. GAO made the point in that report that there may be some technical jobs, highly skilled jobs, professional white-collar jobs, where a 2-year probation may be in order, and we should look at that. But that's not what we're doing here. We're requiring all new federal employees to submit to a 2-year probationary period. And I would respectfully say, I think that if you were a law firm, that would be a real problem recruiting new attorneys. In the technology field, people have other choices where they're not put under that kind of, onerous burden of, I got 2 years before I know my future in this agency. And there are plenty of other places that may have higher pay, better benefits, that don't have that kind of burden. So I just think we need to think that through before we do a government-wide change in the probationary period by doubling it. Thank you, Mr. Chairman.
Okay, I think one last question. Let's suppose that at the end of a year, everything is going great. You get a good evaluation. You're there for a year and 5 months. Are there provisions where you, at the end of the second year is the first time, or can I, as a manager, say, I think we're through a probationary period, we believe you are just fine. Do you have any questions or comments? You're now considered a full-time regular employee. No. 2 years, that's the way it is. You can receive good feedback from your employee. You can provide good feedback from the employer, but at 2 years, it's just a drop dead date. We're gonna go till then. Well, I think I see employees in my business, a year goes really fast up here. And sometimes people see cycles, see things. We kind of do 2-year cycles up here too, and I find I get a better employee.
Right.
Chairman Cole?
Thank you, Mr. Chairman. I want to thank both of you for being here. Excellent members and always thoughtful discussion. Let me ask a couple of really basic questions first. Did I understand or misunderstand? Did you say in Department of Defense there's already a 2-year?
They extended it,
requirement?
yes, and
And
they're very
what-
happy with that.
But did we see a notable number of employees that were removed in the second year? In other words, is there some obvious advantage to that second year?
They, the Department of Defense, they recently switched to a 2-year probationary period with corresponding appeal rights. Department officials recently told committee majority staff there's no evidence to be able to tell that it's hindered in any way being able to acquire new talent. They said extending the probationary period gives new hires a longer opportunity to show improvement before the supervisor has to make a decision, which is good for the employee and the agency.
No,
And this,
and look, I sincerely believe you both are trying to get what's good for the employee and good for the federal government, and good for the taxpayer. I don't have any doubt about that whatsoever. I just want to make sure, I actually have some concern with the point Mr. Conley made about recruitment. I actually have a very large federal workforce in my district, and it does extraordinary. The largest air depot in the world is Tinker Air Force Base. They keep the air transport fleet flying. They keep most of our bomber fleet flying. They do and they're surrounded, by the way, by very high-paying contractors who have a Boeing facility right next to Tinker Air Force Base and employs about 3,000 people. These are really great jobs. I mean, these are, almost 2,000 of those people are engineers. And there is a competition between the private sector and the base, particularly for software engineers that are doing very complex work. And of course, we want them both to have the best employees they can possibly have. They're both excellent employers. I just want to make sure that we don't stumble into something that I put the people that are doing the bulk of the work are still the federal employees on these things. That's the backbone of the system. I want to make sure the federal government is getting very, very good employees. Do either of you see this as something that would hinder it? Now, again, this is defense-related anyway, so perhaps not. I don't know.
Mr. Cole, if I might.
Sure, yeah.
First of all, that's why I think we need to study it. We don't know that answer. No one's done a study saying, here are the results.
Well, and let me give you another instance on this, a different kind of facility that may make this even clearer. We also have the National Severe Storm Laboratory in Norman, Oklahoma. And it is surrounded.
Good place for it, too.
Pardon?
It's a very good place for that.
Well, believe me, we give them a lot of work. But it's also got on the same campus some really great private companies that are in commercial weather forecasting for ships at sea or whatever. The competition for meteorologists, for really high-skilled people between those two kinds of facilities is very intense. And again, we want them both to be there. They're very good. I would worry that a 2-year thing, requirement in that versus if a private company did not have a comparable sort of thing, would give them an advantage. And look, if you live in Tornado Alley, you really want the best weather forecasters in the world. Yeah, please, go ahead.
Mr. Cole, I want to mention this. The Government Managers Coalition, which is comprised of 5 major federal sector professional associations collectively representing the interests of over 200,000 supervisors, managers, and executives serving throughout the federal government. So the General Managers Coalition has advocated for an extended probationary period for over a decade. I wanted to throw that in there. So
Yeah, no, it's important.
Right.
Important to know.
I would like to enter into the record some testimony from a former acting Undersecretary of Defense on this subject. He was Undersecretary for Personnel and Readiness, Peter Levine, and he testified before the Senate Armed Services Committee in March on civilian personnel reform, and he said, The department has done little to take advantage of this legislation already. And then he says, he warned that changing the law to address a small number of problem employees could hurt recruitment and retention and worker productivity. If legislation that is intended to address a problem with 1% of the workforce is perceived as threatening and hostile by the other 99%, it can undermine morale and reduce the department's ability to attract and retain the capable employees that it needs.
Again, this is just, I have a federal heavy district, very different kinds of workforces, two of them big military, but again, cutting edge science stuff, and it does strike me as potentially a problem in recruitment and retention, particularly having watched the federal workforce have to put up with CRs, sequesters, and government shutdowns. I mean, I can tell you, by talking to the commanders of Tinker Air Force Base, what that did to cost us. Now, this isn't where your bill's aimed, obviously, Mr. Comer, but what that did in terms of the retention of really skilled software engineers that were necessary to keep AWACS flying, all of a sudden they'd sort of taken lower pay, for years on the idea that government was secure, and they were proud to be part of defending the country and playing that kind of role. On the other hand, it was like, gosh, this is the way it's going to be. Well, I can walk across the street and get a better paying job, quite frankly, that my employers are not hassling me. I mean, I do think we have hassled our federal workforce well beyond what we should have in the last decade or so between some of these things. And we may be getting ready to do it again with another CR and another sequester. We're days away from that. So anyway, I want to give each of you a chance to make whatever points you care to make, because I'm just musing out loud. So.
Well, and I appreciate that. One thing I want to mention, private companies have at-will employees. So probationary period simply changes appeal rights. So better coworkers should improve retention. And that's just one of the points that I wanted to make.
I mean,
I don't doubt that the intention here is a noble one, but I share your concern.
I think it is. Look, again, I don't have anybody doubts here.
Yeah.
I don't think anybody's out to punish,
No.
people, and I don't think anybody's out here to let somebody that's less than capable slip through the net and have a job. We want the very best people working for the American people. And I think your interests are the same. I'm just kind of wondering a little bit, did we need more study, honestly, to pick up Mr. Connolly's point? Because I will tell you, the workforce that we have, if we ever lost it at Tinker, and we have the same statistics as the average, we have 40%. A lot of these people have done 20 years in the military. They come and then move them back. That's what my dad did. 20 years of very skilled mechanic and 20 years at Tinker Air Force Base doing this kind of work, and was very proud to do it. Thought he was defending the country in both lines of work, and I'm happy to do it. But we've made it very tough on them in recent years. I think we've sort of taken them for granted, and I do not want to stumble into a competitive disadvantage vis-a-vis the private sector. So I just, you both give me a lot to think about here, so I appreciate it very much. And I do want to say this, I do appreciate what I know the motive for the legislation is, because I think it's to get the best deal for the American taxpayer, to make sure that we have the best people working for us, and that we've got a chance to evaluate them. And as you say, maybe we give them a little bit longer chance to demonstrate their value to us. So I think you guys have a very interesting discussion and debate here, but I appreciate the manner in which it's conducted and the motives that each of you bring to the debate.
Thank you, Mr. Cole. Thank you.
Yield, Mr.
Chairman Cole, thank you very much. The gentleman from Massachusetts.
Well, I think I agree with most of what Mr. Cole said in terms of how we treat our federal workers. I have a lot of friends who work in the federal workforce who feel demoralized by the way we treat them here. Not only the government shutdowns, but some of the rhetoric during the debates on the House floor that somehow that they're not valued. And the way I look at this is that this threatens employee protections unnecessarily. So it gives me great pause, which kind of prompts the question, like, what's the rush? I mean, why not do a hearing? Why not do the study? Why not follow this through a little bit more, to either to prove your point or to disprove your point that this is the right thing to do? And I mean, I get, and especially with all that we need to do between now and December, we're facing another government shutdown in a matter of days. I mean, we have to reauthorize the CHIP program. We have 800,000 dreamers whose lives are in the balance, waiting for us to figure out what the hell we're going to do, if anything. I mean, I go right down the list of things, and so, I guess it's a done deal that this is on its way to the floor, but, Mr. Comer, I hope you would be open to making sure that any amendment that people want to offer is made in order so that we could have the most, at least a more open and deliberative process in the House, on the House floor. I mean, would you be open to a open rule or making sure that Mr. Connolly's amendments in order or other amendments in order, or do you have no opinion?
Well, I have an opinion, but right now, I appreciate what Mr. Conley's wanting to do. I certainly do, but I think that there's enough data now that proves that this is something that most managers throughout the federal government want. It's simply more time to evaluate employees. It's worked great in the Department of Defense.
You're going to have fewer and fewer people who want to be employees of the federal government. Because right now, without this, there's enough reason to give you pause as to whether or not this is a career you want. I mean, I'm watching right now the president basically decimating the State Department's employees. I mean, there's incredible work that is done, by our diplomats is being ripped to shreds as if what these people do doesn't make any difference. The constant, the lack of understanding that that a lot of these workers could earn a hell of a lot more in the private sector, and I mean, I'm just telling you. I mean, I've been here now for a while, and I get lots of complaints from federal workers, basically feeling that either we take them for granted or they're our favorite punching bag, and I worry that because of the lack of, quite frankly, no hearings in this Congress. Am I right on that? I mean, why didn't we do it? Why didn't we do a hearing?
If I could go back, again, back to data, we have all the data that we need. In the recent Federal Employee Viewpoint Survey, only 31% of respondents said poor performers who cannot or will not improve are properly dealt with. The GEO office found that from 2004 to 2013, most dismissals for performance occurred during the probationary period. So, and having run a government agency, again, it's very difficult to get rid of a poor performer, and the one bad apple can ruin a whole department, a whole division in government. And this simply gives more time for managers to evaluate employees, and I have not seen a shortage
but if I'm an employee,
applicants for any government agency.
I find this whole approach to be terribly disrespectful, and it diminishes my worth as an employee. And and there's enough that we do here that diminishes the incredible work that so many people do in our government. I mean, the reality is most people who work in our federal agencies do a really good job.
I agree 100% with that, absolutely.
And the deal is whether or not extending this probationary period to 2 years is the solution. I'm not convinced. And I think, maybe a little bit more study and maybe some more hearings could either bolster your position or make you change your mind. Mr. Connolly?
Well, you mentioned the State Department, so here's a piece of data. Does the hollowing out of the State Department, does the so-called reorganization, does the Trump budget cutting 31% from their budget have consequences? So what happened this last year in new recruitment? The number of young people wanting to take the Foreign Service exam and to become Foreign Service officers, down 33%. So the issue of recruitment is a real one, and I do worry about it, and I think Mr. Cole made very good points. One is you can't look at this bill in isolation. You've got to look at it in context. And a lot of federal employees honestly feel under siege, that they've been a pincushion, rhetorically and from policy-wise. I remember testifying before this committee a few years ago when there was a bill to cut benefits from federal employees to use it to finance transit. Right. No nexus. But that, unfortunately, we didn't do it, but we came awfully close. so the context is one of great anxiety, I think, about the future for federal employees. But secondly, your point, Mr. McGovern, and the one I've stressed, why not do this methodically? Let's get a database, let's get some evidence, and maybe GAO says, you know what the Pentagon's doing is what everyone should do. It works so well. If that's the case, I'll be here supporting the bill.
Well, and please go back to regular order, and that includes hearings on bills before they come to the floor, which I think is becoming, a unique occurrence. And a hearing in a previous Congress doesn't cut it. We have a whole bunch of new members on your committee and in Congress, and, we ought to do this the right way.
And let me say this with respect to hearings, the testimony from hearings discussed probationary period extension,
Did you have a hearing in this Congress?
July 11th, 2014.
Well,
Oversight
2017.
of the federal workforce, the viability of the senior executive service. So it has had,
Well, with respect, it's 2017, and there are a lot of new members of Congress.
and May 18th of 2017, obviously.
You had a hearing
Right.
on this bill?
Question, in the form of a question for the record.
Well, all right. Well, that's not, we have very different opinions of what regular order is and the way this plays. But a question that's asked, that's not a hearing on the bill. Anyway, whatever. I yield back. Thank you.
Thank you, gentlemen. Gentleman from Georgia.
Thank you, Mr. Chairman. I think you heard from my friend from Massachusetts a lot of frustration about a lot of different things. I think sometimes our federal employees get caught up in that same challenge. There's lots to be frustrated about when you serve in the United States Congress, things you want to get done that you can't get done, and there's lots to be frustrated about when you're a citizen and you're trying to fight your way through a federal bureaucracy. Some days you find people who are there working as hard as they can to serve you because they know you're the boss, and the next day you walk in and you find somebody who thinks you're an inconvenience and wonders why their job includes having to answer the telephone. It's my considered opinion, as someone who has been a federal employee, both sitting in this job and sitting in others, is that we do folks a favor. I know Mr. Connolly's got a lot of constituents who are involved in this honorable kind of work. The more we do to make sure that there's a gold standard that federal employment represents, instead of a floor or a ceiling that federal employment represents, the better off we are. We can study things to death here, and is 2 years more arbitrary than 1 year is? I don't think that it is. Are we worried that we have managers in these places that are going to abuse a 2-year probationary period in ways they would not abuse a 1-year probationary period? If we are concerned about that, we should be taking steps to deal with those managers, because abusing your probationary status for 12 months is not superior to abusing it for 24 months. I think about the work that was done from a VA perspective, where we came together and said, you know what? There are civil service protections that we absolutely positively have to continue, because these are honorable men and women who are doing their very best, and you shouldn't get fired just because you're a Republican or a Democrat and the White House changes hands. But we also said, for Pete's sakes, there are things that we can do better. And when we identified veterans as that really honored category of people we were going to serve, we came together in a bipartisan way and said, let's make some changes to improve the quality of our personnel and service to these folks. Even if this bill isn't going to be that partnership part two, I'll ask you, Mr. Connolly, because again, you represent so many men and women who are involved in this service. Do you see a window of opportunity over the next 14 months that we can come together to say, you know what, sometimes we're on the side of protecting good employees from bad managers, and other times we seem to err on the side of protecting bad employees from good managers. Is there an opportunity to come together?
I think there is. I think the sequencing here, though, is what bothers me.
Sure.
The GAO report said we need more training of those managers you're talking about, Mr. Woodall, so that they're doing a better job of using the time they've got to evaluate. So we got to try to systematize that. And to me, that's sort of step number one. Because you could have a probationary period for 10 years. If you don't solve that problem, the evaluation is still lousy and unproductive. But I don't think we want to underestimate the potential, unintended consequence of discouraging people who have other options, especially at the high skill end. Mr. Cole was saying just before you got here about, in his district, obviously, Tornado Alley, having the federal capability with highly skilled meteorologists and others to protect the public, really critical. It's not like they don't have other options. And so we're competing at the high-end skill set for lawyers, technicians, scientists, you name it. And I would argue, how many physicists are going to agree if they have alternatives at a university or a private lab, right, to a 2-year probationary period when they can go across the street and get a job and be high and mighty after 6 months? And so I just think there are some unintended consequences potentially. I think they are resolved by having an analysis of, well, how's it working where we already have it at the Pentagon? And there's conflicting anecdotal information, but there's nothing, we haven't done a study that convinces us all one way or the other. And as I said, frankly, if we had such a study by the GAO and it said, actually, it's working beautifully at the Pentagon and it ought to be adopted by every federal agency, you got my vote.
That conflict between trying to gather good data and sitting around and doing nothing when we could be doing something is one that vexes me on a regular basis. I appreciate Mr. Comer for bringing this forward and trying to take a positive step. I really do believe the best thing we can do for federal employees is to have them viewed by their bosses, the American taxpayer, as being the absolute finest workforce that anyone can provide. I have the pleasure of representing very many CDC employees. You talk about having a competitive disadvantage. You work at the CDC for one reason only, and that's that you want to stand between catastrophic disease and the American people. And you choose to do that almost always to your financial peril, because we just can't compete with the pharmaceutical companies of the world. But it's a calling, and folks do it. I hope that we will be able to find that trust with one another, that we can agree that there's a federal workforce that needs to be staffed, and folks need to be thanked for their service in that workforce. And there are folks in that workforce, just like there are at every single private company in America, that need to go. And candidly, my constituency expects more of us than they do from a private company. You put a 47-inch flat screen, well, 47 is not big anymore. You put a 97-inch flat screen TV up on your wall in your the local gas station. Folks say, knock yourself out. If it's your money, spend it how you want to. You put a 97-inch television up in the Connolly office, and folks say, hey, wait a minute, Congressman, how are you spending my money? That doesn't seem quite right. I think it's only natural that we're involved in this in this frustrating space, but I will tell you that I have great optimism, given the leadership that we have here, that even though this is kind of a partisan environment that we're living in November, that over these next many months we can do more. Doing nothing to raise the enthusiasm that the American taxpayer has for workers on their payroll, I will tell you, is failing those workers, failing the American people also, but failing those workers most of all. Mr. Conley?
You made a really good point about your own district, and just as Mr. Cole did in his district, and I have lots of examples of mine. It would be interesting to really get some honest feedback from CDC. What would a 2-year probationary period do to your ability to recruit the next generation of scientists and technicians we desperately need to as the front line against epidemics and pandemics and so forth in the United States? And that's all I'm arguing, really bottom line. Let's get that kind of data. Let's do that kind of survey on the scientific. I said before you got here, but we just a month or two ago adopted a bill that said we want policy to be evidence-based. Well, here's an opportunity for us, not that hard, to get the evidence. And if it's convincing, I think you'll have broad bipartisan support for this bill.
The exception to that being that we have to go to the CDC and ask them to speculate on what the future would be. I have in my district the first four-year university that the state of Georgia has created in almost a century, and there's no tenure there. No tenure for professors there. And folks said, absolutely, you're going to create this, Rob. It's going to be a terrible failure. Why in the world would a top-notch professor come and teach at Georgia Gwinnett College when they could go somewhere else and know that they're protected for as long as they want to be there? Well, I was just visiting with our university president during the last district work period. He said he's traveling around the country now teaching and sharing his experience, because we have not only brought test scores through the roof, we're not only the most diverse university in the country today, we not only are controlling tuition growth as no other institution is, but the eat what you kill mentality of that cadre of professors is bringing together a atmosphere of excellence where everyone knows that all of their colleagues are carrying their weight, or else they won't be there tomorrow. It's a fascinating thing to watch. I could not have taken a poll through the Chronicle of Higher Education and said, hey, what's going to happen if we do away with tenure? And had anybody say, oh, it's going to be fabulous, Rob, you're going to develop the finest experiment in higher education to be known. Candidly, we count on members like you, Mr. Connolly, who have these constituencies to be the voice defending those constituencies. And we count on other folks to be the voices who are challenging the status quo, and then we count on being able to come together to get that done. I'm not opposed to evidence-based legislating. In fact, I'm aggressively supportive of it. But I am challenged in places like this, where the only person who's doing it this way is the federal government, how it is that I can go and get that other than just by asking for people's opinions. There's sometimes no reward, Mr. Comer, in challenging the status quo, but I appreciate you doing it. And candidly, while I'm going to support you on this, if it turns out that it doesn't work, I'll support moving it right back the other direction either. I'm not invested in your solution in particular. I'm just invested in moving the ball forward, and I'm grateful to you for doing that.
Thank you.
Mr. Chairman, I yield back.
Thank you, gentlemen. Gentleman from Florida.
So determining whether or not, Mr. Woodall, it's good or bad, is that going to take you 1 year or 2 years or 4 to determine whether or not it's working?
I confess it's going to take me longer than a committee hearing that takes place in an afternoon. It absolutely would. I need to hear the frustrations of folks who are dismissed in month 18 of their probationary period about why it was that it would be better if they remained in the service of the federal government, even though their performance is subpar, rather than being
Well,
dismissed.
why wouldn't we try to get that information in advance when there's no rush for this particular measure? The civil service has been in existence since 1871. And the last time it was reformed in a meaningful way was 1978. So here we are now with piecemeal measures, some that are perceived, at least by many in the civil service community, as harmful to their interests. But let me turn to you, Mr. Comer. You said that you were the Commissioner of Agriculture, and you learned that there were problems in getting rid of people. I don't know Kentucky's civil service plan, but I assume they have one.
Called the
Is
merit
that it?
system. Yes, sir.
Right. Did you do anything in Kentucky? Did you offer to the legislature a similar measure like this, that there be an extended probationary period?
I've given a lot of speeches about it, and, the response has always been overwhelming. People that if you presented this to the taxpayers in my district, I don't know about everyone else's district, they would be overwhelmingly in favor of this. The first thing they would say is, this is a lot better. 2-year probationary period is still a better deal than the private sector.
My question was, did you offer it up to the legislature as Commissioner of Agriculture for a measure to change Kentucky's civil service?
Did I offer a particular legislation? No,
just talked
as a
about it.
constitutional officer, I wasn't in the legislature anymore, but I think that it should. I think every state should do that.
As the author of this legislation, then what did you do to come to this particular conclusion? Or did you speak with a significant number of managers in civil service and a variety of them, since there are such a
I've
plethora
spoken-
of interest in the civil service?
Right. I've spoken with several managers in the Department of Agriculture and Department of Energy. They all thought this was a good idea, something that's been needed. Again, I've probably not done a very good job of citing the data. There is a lot of data out there. Again, the Government Managers Coalition has been advocating for this probationary period extension for over a decade. So I think that it's something that certainly needs to be done.
I respect that, and since you spoke with managers, did you speak with employees? Did you speak with labor unions, for example, the AFL-CIO or the American Federation of Professional and Technical Engineers, a whole bunch of them that Mr. Connolly talks to pretty much every day of his existence when he's in his district? Did you talk with any of them?
I did not talk to any union representatives, no.
Then, Mr. Chairman, I ask that I be permitted under unanimous consent to include three letters that I have in hand, all dated currently either the 27th or the 28th of November. The AFL-CIO alert and the International Federation of Professional and Technical Engineers, and the American Federation of Government Employees.
Without objection.
Now, Mr. Coleman, the American Federation of Government Employees says that extending the probation period reduces the due process rights of employees. What's your reaction to that?
I 100% disagree, and the probationary employees have due process rights. Discrimination or retaliation in violation of the Civil Rights Act may be addressed via equal employment opportunity claim with an employing agency. Adverse personnel actions based on marital status or political affiliation can be appealed to the Merit System Protection Board. And the Office of Special Counsel investigates allegations of retaliation based on whistleblowing. So,
But does a probationary person have those rights?
yes, probationary employees have due process rights.
Mr. Connolly?
I think it's misleading to suggest that the rights are the same as a permanent employee. As a matter of fact, if you're on probation, there are limited due process rights and appeals rights. During this period, an employee can be fired with 30 days' notice, and they have limited rights, unlike regular employees, to an attorney or a representative. The agency in question is only obligated to notify the probationary employee of his or her inadequate performance or conduct and the effective date of separation. Probationary employees can only appeal a dismissal action to the Merit Systems Protection Board if the employee is in the competitive service and alleges the removal was based on partisan political reasons, the employee's marital status or failure to comply with procedural requirements where the termination was based on
Now,
conditions of
Mr.
arrest.
Connolly,
Yes, sir.
what happens to a whistleblower?
Again, the Office of Special Counsel investigates allegations of retaliation based on whistleblowing, even with even with employees that have not met their probationary period, exceeded that. So they still have.
I'm pleased that you answered, but I did ask Mr. Connolly at that time, but it's no problem. Mr. Connolly
Oh,
can
I'm sorry, I
tell
thought
me
you
now.
said Comer.
No,
I
no,
apologize.
your names are similar. I
Okay, I
understand.
apologize.
Oh,
Well, I wear hair days. I
Yeah,
apologize.
yeah,
All right,
okay.
My bad.
I think it's his accent.
Yeah.
Well, the same thing would apply to a whistleblower. If you're in
That
this
is it.
probationary
That's what I
period,
thought.
you get limited rights of protection.
Pass these on to the young lady over there. I do have good news for us. I don't know how many members know, but we aren't going to have any more votes today. So I'll cut off some of my talking here so we can get on out of here. But
Gentleman's recognized for additional time.
having said that, Mr. Chairman, I do want to ask in this instance, Mr. Comer, let's say hypothetically that this bill were to become law. And if an employee of the civil service who's still serving in his or her probationary period were to change jobs or transfer to another position, how does it affect them, and would the employee's probationary status start all over again? Or does the employee keep his or her vestment?
It's my understanding that if they switch positions, their probationary period carries over with them.
That's a good thing. Now let me ask you, I have 4 amendments to this measure, so obviously I've spent a little time
Yes, sir.
Looking at it. The one that I'm most interested in, that I believe you are as well, and Mr. Connolly and all of us, we espouse the value of veterans. So do you believe that veterans who have served our country and are now employed as civil servants in the United States government should be able to be fired without appeal?
Well, the Department of Defense already has extended the probationary period to 2 years.
Well, no, I'm not talking about someone
about-
working at the Department of Defense.
Okay.
But a veteran who comes out and goes to work for one of the agencies that you did talk with people, well, what happens to that veteran?
And again, I have a lot of veterans in my district. My father's a Vietnam veteran. I don't think that, I don't think it treats, I don't understand why we treat veterans,
You're stumbling, Mr. Combs.
well,
Yeah, it's a hard question.
well, it's
isn't
a
it?
hard question. I'm trying, in an age of political correctness, if you're a good employee, you're gonna be there. It's hard to find, if you prove yourself, no one's going to get rid of a bad employee. That's been my experience in
Yeah, but you
government.
see,
That's been everybody, and certainly no one's going to discriminate
Reclaim
against
my
a
time for just a
veteran.
moment.
Right.
What I'm getting at is, this person has already served, and that's
Mm-hmm.
not only as it pertains to veterans, it would also be true of Peace Corps and a whole bunch of other areas. So why shouldn't they be, right here in Congress,
Mm-hmm.
we give them a leg up. They get a leg up for housing still, and many of our foreparents got their first house and their first education through measures because we value their service. So why is it now they need to be on 2 years probationary service after having served 2 years or more in the military?
And I think a longer probationary period helps veterans just like it helps everyone. I support a 2-year probationary period, and again, most of the managers within the federal government that I've spoken to support this. The Department of Defense was the first big cabinet that went to the 2-year probationary period. So I think if the Department of Defense has proven that it's working and effective, I think it's good for all of our veterans.
Well, I appreciate you and Mr. Connolly. I quite frankly think, even though you have the great experience that you had as the Commissioner of Agriculture in Kentucky, I think that Mr. Connolly and the people in the near curtilage that are Republican and Democrat that have these significant numbers of civil service people, I don't think that the 100 letters that I got complaining about your measure is sufficient from 100 civil servants in a limited district like mine. But if I was going to the bank on something for civil servants, I'd quite honestly take Mr. Connolly over you, with no offense meant to you, nor the diligence that you and your staff have evidently put in this. But in honor of the fact that we are going to get out of here, I'll stop now. I yield back, Mr. Chair.
Thank you, gentlemen. Gentleman from Alabama. Thank you. Gentleman from Colorado. No questions. I want to thank both our witnesses for appearing, and no further questions. You're both excused, but thank you again for an excellent testimony.
Thank you. Thank you all for your time. Yeah.
He's coming back, but if you want to start.
Okay. Okay. As our witnesses are leaving, do any other amendment, or any other members seek to testify on Qualified Civil Service Act
Yes,
of
Mr. Chairman.
2017?
Yes, Mr. Chairman.
Seeing none.
Mr. Chairman,
Mr. Hastings.
Oh, I'm sorry.
I was saying yes, that's okay. I have 4 amendments, Mr. Chairman. And I will be brief. These amendments would exempt certain groups and individuals from the 2-year probationary period. And in an effort to save time, I've already spoken to the issue with reference to veterans, and I also think it should include Peace Corps and AmeriCorps and Americans with Disabilities and minorities. And those are the 4 groups that I've sought in my amendments to be exempt. And I'll put my statement in the record with the rest of it as unanimous consent that my full
I
statement.
think, my friend, I apologize for overlooking him down there for a second.
No problem, none whatsoever.
Any other members care to testify on this bill? Okay, if we can, we'll have our next panel come up. It's a very familiar pair. It's great to have you both back again. It's always great testimony. So we will be moving to H.R. 1699, the Preserving Access to Manufactured Housing Act of 2017. Mr. Chairman, it's a pleasure again to have you here. You're making these last every minute count on your way out. I'll just for the record once again urge you to reconsider in these final days before filing ends in Texas. I will miss you very much. But my good friend is recognized for his testimony. Then we'll move to my good friend, the ranking member.
Thank you, Congressman Cole, for the kind words. Members of the Rules Committee, thank you again for the opportunity to testify on bipartisan legislation that was recently approved by the Financial Services Committee by a vote of 42 to 18, and a piece of legislation that has a long, strong bipartisan record. This legislation is a narrowly focused, modest effort to help Americans, particularly those of low and moderate incomes, to achieve greater level of financial independence by being able to afford a home they can actually keep, in this case, a manufactured home. H.R. 1699 is the Preserving Access to Manufactured Housing Act. As I've mentioned, this bill has earned the support of both Republicans and Democrats because it is a common-sense solution to a real problem facing a lot of struggling families, and that is the issue of affordable housing. Nearly 6 members from both sides of the aisle are co-sponsoring this bill offered by our colleague from Kentucky, Mr. Barr, including Democratic co-sponsors Mr. Gottheimer of New Jersey, Ms. Sinema and Mr. O'Halloran of Arizona, Mr. DeFazio of Oregon, and Ms. Rice of New York, as well as Ms. Sewell of Alabama. H.R. 1699 provides technical clarifications to the definition of, quote, mortgage originator and, quote, loan originator, and also amends the definition of a, quote, high-cost mortgage under the Home Ownership and Equity Protection Act to ensure that consumers of small balance mortgage loans have access to mortgage credit. Under the CFPB's rules, many small balance manufactured home loans are now being considered, quote, high cost, thereby restricting credit access, again, particularly to low and moderate income consumers who are seeking a manufactured home. Manufactured homes provide many consumers who have limited credit and housing options with the opportunity to actually own a home. Many consumers who live in rural areas, like much of the 5th District of Texas that I have the opportunity to proudly represent, they do not have access to rental options or other affordable housing, and the CFPB rules are unfairly penalizing them. Retirees, veterans, rural residents, and working families that simply want to buy a manufactured home. These families are being denied financing for certain manufactured homes, again, particularly for lower-priced, more affordable homes. This bipartisan bill clarifies that a manufactured home salesperson is not originating a loan when helping a consumer apply for a mortgage or prepare loan information unless they are compensated by a creditor, lender, or mortgage broker. These minor but important technical clarifications will help preserve consumer choice and financing options, again, for those seeking to buy a manufactured home. While leaving important consumer protections in place, loans under this bill will still be covered by laws like Truth in Lending Act and state consumer protection laws. Our committee has heard from small-town community financial institutions all across the country that H.R. 1699 is vitally needed because low and moderate income customers are having this affordable housing option taken from them. For example, a community credit union in New Mexico writes in to tell us that these regulations have forced his institution, quote, to discontinue offering mobile home loans, unquote, despite the fact that, quote, mobile home buyers are common in our area and our loans would be priced competitively for mobile homes and should not be considered high cost. Similarly, a lender in Oregon writes that this Washington red tape has eliminated at least $350,000 worth of credit for his consumers looking to purchase mobile homes, quote, thus denying access for about 10 consumer borrowers that would otherwise benefit from these loans, he said. He goes on to write, the Bureau, in this case referring to the CFPB, may deem this impact insignificant, yet for the consumers of our country and for our small lending institution, it is significant. To help consumers throughout the nation, I encourage this committee to adopt a rule providing for the consideration of H.R. 1699, again, a modest and bipartisan bill that will certainly help low and middle income Americans achieve their dream of home ownership. It will help them purchase affordable housing. And I welcome your questions, and again, thank you for the opportunity to testify.
Thank you, Mr. Chairman. We'll now go to our good friend, the gentlelady from California, distinguished ranking member of the Financial Services Committee, for her opening statement.
Thank you very much to all of the members of the Rules Committee. I am very appreciative for the opportunity to speak on H.R. 1699. This measure, the Preserving Access to Manufactured Housing Act, rolls back key protections for homeowners and leaves consumers vulnerable to the same kinds of predatory lending practices that are all too common during the period leading up to the financial crisis. Make no mistake, this bill would facilitate the kind of steering that forced so many high-cost mortgages that ended in foreclosure and undermined vital consumer protections enacted as part of the Dodd-Frank Wall Street Reform Act. Mr. Chairman, H.R. 1699 would cement the manufactured housing sector as one that is rife with high-cost loans and limited consumer protections. It would do away with changes made by Dodd-Frank and the Consumer Financial Protection Bureau to establish enhanced disclosures and homeownership counseling for borrowers facing high-cost loans. The measure would allow lenders to charge 10% over the prime rate while being exempt from enhanced disclosures and protections. With prime rates today at about 4.25%, this proposal would eliminate protections for home loans with interest rates that are over 4 times what other borrowers are paying. It would also allow lenders to triple their upfront fees on smaller loans and allow salespeople to engage in high-pressure sales tactics to steer customers into high-price loans without being subject to the same regulations as other mortgage professionals. Indeed, some of our most important consumer protection laws, like TILA, the SAFE Act, and HOPA, would no longer apply to manufactured housing retailers and salespeople that offer credit to borrowers, even if those salespeople do the same things traditional loan originators do, like referring customers to a creditor or assisting them in applying for credit. An investigation of the mobile home industry by the Seattle Times, an extensive investigation, paints a disturbing picture that has unfortunately become all too common. Vulnerable consumers are steered into high-cost mortgages that they cannot afford. They fall behind in their payments, subjecting them to aggressive collection practices. Their property is repossessed, and their credit is left in shambles. All the while, multi-billion-dollar dealer financing monopolies like Berkshire Hathaway, which owns the notorious Clayton Homes, reap the benefits. These businesses gain significant financial profits from unsuspecting consumers, from producing the housing to selling the housing to originating loans that take advantage of vulnerable consumers that leave them with virtually no way to refinance. The Consumer Bureau's 2014 report on the manufactured housing industry found that 68% of manufacturing housing loans are already considered higher-priced mortgage loans, and consumers seeking to purchase manufactured housing tend to be older and have lower net worth than families living in other types of housing. Most notably, the study concluded that these same groups of consumers that apply for loans for manufactured housing include consumers that may be considered more financially vulnerable and thus may particularly stand to benefit from strong consumer protections. And H.R. 1699 would undermine existing protections to the detriment of a particularly vulnerable group of consumers. Making matters worse, the manufactured housing industry has yet to produce convincing evidence that current law has substantially restricted their business or access to credit. According to the Industry Trade Association, known as the Manufactured Housing Institute, the number of manufactured home shipments has steadily increased over the past 4 years, with over $5.7 billion in estimated retail sales in 2016. Meanwhile, the Manufactured Housing Association for Regulatory Reform found that industry production has continued to increase over the past 6 years. And while businesses like Clayton Homes are rolling in profits, it is the families in rural, underserved areas that are suffering. For example, the Seattle Times investigation I previously mentioned documented the case of Dorothy Mansfield, a disabled Army veteran that previously lost a home to a tornado in 2011 and was approved for a $60,000 20-year loan to buy a Clayton home at 10.13% interest. She owned the land free and clear. Her dealer wrote the loan on a no documentation basis and never bothered to verify Mansfield's income or employment. Mansfield's monthly payment ultimately consumed $673 of her $700 a month Army disability benefit. With 18 months, she was behind on payments, and Clayton was trying to foreclose on the home and land. We should be doing more to help consumers like Dorothy, not making this type of abuse easier and more profitable. Again, I will remind you that Warren Buffett and Clayton Homes had a profit of $744 million in 2016. Mr. Chairman, I certainly cannot support a proposal that would exempt thousands of consumers looking at high-cost mortgages from the vital protections and scrutiny they deserve. Low-income and rural families that rely on manufactured housing as their only affordable option deserve the same anti-predatory lending standards as all other home buyers. A broad coalition, including civil rights groups, affordable housing advocates, academics, and consumer advocates also oppose this measure. Again, I thank you for having me here today, and I yield back the balance
Thank you
of
very
my
much.
time.
I appreciate not only your feedback to us, but your interest in this issue. Chairman Cole?
Mr. Chairman, I actually have no questions to either of our distinguished visitors, so I yield back.
Thank you very much. Mr. McGovern?
Well, thank you very much. Well, thank you both for being here. I agree with Maxine. And I hope that this will be brought to the floor in a way that members can offer different ideas. So with that, I yield back.
Thank you very much. The distinguished gentleman from Georgia.
Thank you, Mr. Chairman. I just want to make sure I understood, because I'm conflicted about a lot of these issues. The story that you told, Ms. Waters, about the Army veteran having her home repossessed. That's what's going to happen if you have a home payment that consumes 95% of your entire monthly income. And I can't understand if our goal is to make sure that folks get counseling such that they never sign up for that loan, which would tend to both protect that consumer from losing their mobile home, but also prevent that consumer from even considering the purchase of a mobile home. What is is our goal? Are we disagreeing about whether or not this legislation would allow more people to purchase mobile homes? Because it seems very clear that it would. The worse credit risk I am, the higher interest you're going to have to charge me in order to sell me your product. Are we disagreeing that this legislation would in fact allow more people to have access to homes? Or are we disagreeing that those people should have access to homes, and the proper ending for the story that you told is not that the woman loses her home, but that she never purchases that home to begin with?
The first thing I think we should consider is that this vulnerable population of folks who may not have a lot of options and who wish to have a manufactured home should not be charged extraordinarily high interest rates above and beyond what other buyers purchasing homes would be charged. That's number one. This industry is saying, in order for us to make more money, we've got to be allowed to charge extraordinarily high interest rates. That's number one. Without having the same kind of disclosures and protections, these consumers are suckered into loans where there is no documentation about their income. And just like Dorothy, who had limited income on Army disability for $700 a month, nobody cared to find out if she could really afford the home or where she was going to be able to get the money to buy food and take care of other necessities. They just put her into the mortgage. They put her into it. And of course, she tried. Oftentimes, these people would go to other relatives. They would try and borrow money. Sometimes even veterans who are disabled will try and get a part-time job to keep up with these payments. But 9 times out of 10, as hard as they try, and maybe they stay in for a year or 2 years, maybe even 3 years, they're going to lose that home.
And is the opinion of the industry that folks are making lots of money by repossessing a used mobile home and then reselling it to someone else? I mean, I would think as a lender, I'm going to be advantaged if you continue making payments and I don't have to repossess your home. Worst case scenario for lenders in my district is that they have to get involved in a repossession. But I'm trying to understand how folks are being, how the industry is profiting from repossessing homes. That seems like a loser to me.
Well, you just said it. Dorothy, as I said, may stay in the home 1, 2, 3, maybe even 4 years. She's got a 20-year mortgage. She scraped together everything that she could scrape together in order to keep it up, but she couldn't keep it up. And so, they back up the trailer or whatever it is, and they repossess the home, and yes, they resell it.
Mr. Chairman, Bankrate.com tells me the average credit card rate today is about 16.7, which makes that prime plus 12 today for the average unsecured loan. What is the answer?
What mortgage are you talking about?
Credit card rates. Credit card rates. Unsecured
Oh, no,
loans.
my comparison is not with credit card rates. It is with the market rate for home mortgages.
Absolutely.
And that's what we're talking about.
And homes being a very stable, traditionally, asset, manufactured homes being less stable, as reselling a manufactured home involves towing it off of the property on which it sits, carting it across town or across the country, and then relocating it on yet a different piece of property. What is the gentlelady suggests we should treat this more as a home and less as an unsecured loan. What's the experience from the committee? Is this the quality loan asset that a home is?
Well, in some respects, perhaps I would argue it is a bit of a hybrid. Number one, it is a very important form of affordable housing. And I'm afraid that if we do not enact this legislation, that this form of affordable housing is going to be denied to people throughout our country. And it is clear that many people would prefer to own a manufactured home than end up having to rent. And so I could read through a number of letters from people, a 28-year-old single mother of 2 children who was employed by a nurse. As a nurse, total monthly income of $3,000. She was able to purchase a manufactured home for $11,000 with a down payment of $2,000. And she said, quote, "We looked at other rental options, but they were more per month. and we felt we would just be giving our money away. Unfortunately, if we stick with status quo, we're going to force a lot of low-income people to just give their money away in rental when many of them would prefer to own. So that would be my first point. But it is, for a lender, sometimes a riskier loan. Why is it a riskier loan? Many of these people have bad credit records. And so that can be a riskier loan. And because this is not necessarily firmly affixed to the real estate, quite literally, your investment could be put on wheels and rolled across state lines to another jurisdiction. And so unfortunately, I think what the ranking member has suggested is some form of federal price controls, which of course is going to squeeze people out of the market and force them into rental options that they may not want. I would also use this opportunity to say that contrary to the implication posited by the ranking member, these loans are still going to be subject to all types of consumer protections, including the Depository Institutions Deregulation Monetary Control Act, the Equal Credit Opportunity Act, the Fair Housing Act, the Fair Credit Reporting Act, Graham-Leach-Bliley Truth in Lending Act, Home Mortgage Disclosure Act, Real Estate Settlement and Procedures Act. I mean, I could go through about 20 other major consumer protection laws that these will still be subject. But what happened was we've had these quote-unquote high-cost loans of HOPA on the books for about 2 decades. But under the recently passed Dodd-Frank law, not so recently passed now, they gave the CFPB the discretion of really changing the definitions. And so all of a sudden, a few years ago, I think it was 2014, they finalized a rule that expanded who came within the ambit of this quote-unquote high-cost definition. And that captured so many manufactured homes. And again, every day we turn around, we're getting some correspondence. Here's one from Five County Credit Union of Maine. Since October of 2010, Five County has no longer been offering mobile home loans to its members due to the interest rate limitations of high rate, high fee restrictions in federal legislation. I heard from Zia Credit Union in New Mexico. Basically because of this CFPB rule, quote, we have been unable to offer mobile home loans to our members for the past 2 years. I've got quotes from Oregon credit unions, Montana community banks. And so, again, if we believe in affordable housing, we ought to allow people to have access to manufactured housing. And if we keep with the current CFPB rule, they just simply will not have the access.
Well, thank you, Mr. Chairman. I agree with Ms. Waters that they're predatory lenders in the marketplace. I appreciate you citing those credit unions because I know credit unions that are charging high-cost loans to borrowers who could not get money anywhere else in the state, but the credit union is believing in them and investing in them and helping to lift themselves, helping to lift this family up again after they have fallen on hard times. So I know the folks that you cite are interested in the family's well-being as well. Mr. Chairman, I say to folks back home, if it was easy, we'd have done it already. It strikes me that here we are having a conversation about whether or not folks ought to be able to have no documentation loans, and should we be expanding the access to homes or not. If we were having this conversation about Fannie Mae and Freddie Mac and federal housing policy, we might have folks switched in their chairs, Mr. Chairman.
Thank you. If I could make 2 other points, and this is common sense, but I think it bears repeating. Whether your closing costs are applied to a $20,000 loan or a $200,000 loan, those closing costs are approximately the same. But as a percentage rate, they are much higher on a $20,000 loan, which can kick it into this high-cost area, which increases liability exposure for the lender, which causes the lender to no longer want to do this. So some would point out, well, wait a second, your APR may be higher on a manufactured home than an in-site built home, but your monthly payment, generally speaking, is going to be a lot lower, since the average manufactured home, somewhere in the neighborhood of $40,000, $42,000, your average in-site built home probably approaching $200,000. So your monthly payment, if you're a moderate to low income person, is still going to be much more affordable on a manufactured home.
Mr. Chairman, I think we should take heed of the admonition against predatory lenders. I think we should also take note that not one of those credit unions falls into that category. Those are people who are trying to lift these families back up again, trying to let them grab that rung of the economic ladder and achieve the American dream. It is easy to lump all these financial institutions into the same basket. These are folks who believe in these communities, not folks who are trying to exploit them. I yield back.
Thank you very much. Gentleman from Florida, Judge Hastings.
Ms. Waters, whether or not she had updated the Seattle Times article. It's December 26, 2015. Is there any more current info showing all of these bad predatory actions that have taken place?
I don't think we have any more recent information than that. But what we do know is that the lender-dealer mobile home profits have continued to increase annually, even after the CFPB rule.
Right. Well, I do believe because of the comprehensiveness of this particular article, Mr. Chairman, I would ask unanimous consent that it be made a part of the
That
record.
objection will enter that
All
into
right.
the record.
With that in mind, I don't know about any of you, but I lived in a manufactured home with my mother. And I did perceive at the time that the rates were, in many respects, usurious. But I feel that way about just about all of this finance and business, including American Express and all the rest of them. But let me point out to Mr. Hensarling, who is leaving, and Ms. Waters, who is staying, and others in the financial services office, and experience, and it won't take me but a minute. In the last 3 weeks, I bought a home, and I'm selling another. I learned from my mortgage broker, a man named Dan Fazio, when we were going through the process, the hoops that I had to jump through. I have a 780 credit score. I have always paid my bills on time. But what I ran into is something that you all might want to address, is the 43% debt to income.
Yeah,
With the salary that we make
yeah,
and with the ordinary expenses that I have,
yeah.
that was a continuing problem. But worse yet, there is a requirement. I didn't bother to cite, bring the cite with me, but there is a requirement in the law that you have to have more than 2 years prospective, not retrospective, but prospective employment. So the fact that I'm on this job 25 years or had another job for 13 years is of no moment to the lender. And I found that passing strange. And what I said to them ultimately was no congressperson
That's right.
would apply for any, qualify for any loan. I just want to pass that on to you all, because there is something out there that's particularly distressing when it comes to even those of us that have good credit.
If I may,
trying to
Mr.
get
Chairman,
credit.
I'd like to.
Sure.
The gentleman controls time, and
Yes, Mr.
we're delighted.
Let me just say that, no, I was not aware that was any mortgage contract, and you're absolutely correct. I mean, it is unreasonable to ask someone who has been employed for 25 years whether or not they can guarantee you that they're going to be employed for 2 more years in order to be, a credible borrower, and that should not be in the law. And I certainly.
It's in the law, and I intend to work.
Okay, and I intend to work with you.
Mr. Hensarling.
Well, I feel your pain, having purchased a new home approximately a year ago. So
Don't
I had
do
a
them same
similar,
moves.
experience, Mr. Hastings. I would say that regrettably, when the CFPB promulgated their qualified mortgage rule, they came up with a strict 43% debt to income ratio. They have what is known as a GSE patch, which exempted a number of mortgages from that. But when fully phased in without the GSE patch, it's roughly 20% of individuals who qualified for a mortgage as recently as 2010 can no longer qualify for a federally insured mortgage. And I think that's just wrong to have one indicator. I mean, it's almost like you don't care about your earning history, you don't care about your credit score, you don't care about your net wealth. All we care about is your debt-to-income ratio, 43%, north or south. We don't care about your character, and so that's not helpful.
Yeah,
Okay, but if I may,
sure.
on your time, what you did not have, and you won't have in any conversations other than like in manufactured housing, lenders who will be charging you 10% above the market rate of 4.25%. I mean, this is extraordinary, and these are your most vulnerable people with the lowest incomes who desire to try and have what they would consider a decent place to live. And with all of the protections that are stripped away from these kinds of sales, you have vulnerable people put into an even more vulnerable situation, and 9 times out of 10, with no documentation of those loans, they're going to lose those homes. And if Mr. Woodwall is thinking that perhaps the cost to the lender is so extraordinary that they would not want to be repossessing these homes, I would disagree with you there, that they certainly could repossess and resell without extraordinary cost, and this would not be a deterrent to them repossessing a manufactured home.
Of course I will.
Are you suggesting, because I was drawing my conclusion from what those credit unions said.
Yeah.
Right, that they used to make loans, but because of their lower rate now, they can no longer make those loans because they can't justify it on their books. I took that to mean there was no security in repossessing that home. Do you draw a different conclusion
Yeah,
from those
I do.
credit union?
Well, what I'm saying is this. The credit unions probably could not compete with Clayton Homes, for example, Berkshire, because there's a kind of a monopoly in this area. There are only a few people who do it, and Clayton is the biggest. And I think that given their sales tactics and given the way that they do business, it's very hard for a regular credit union to compete with them out there in that market. And so they get out of it because it's just not a good market for them.
I drew a different conclusion, but I take
Yeah.
your point. I thank my friend for yielding.
Thanks, and I yield back, Mr. Chairman.
Gentleman yields back his time. Thank you very much. Gentleman from Louisville, Texas. Gentleman does not seek time. The gentleman from Colorado.
I was just wondering if there's any changes between the version of the bill this Congress and the one that went through last Congress. I'll ask the chair and the ranking member.
It's the same bill.
Same bill.
So there
Oh, I
is one
understand they did
modification.
add one little, go ahead.
Please.
Because you did it, I guess, added a little bit more protection. That's why he's able to talk about the SAFE Act, but I did not talk about all
There is a
of-
modification to the term loan originator under the SAFE Act. Otherwise, it's the same bill that you saw in the last.
And what happened to the bill last session? Was it passed the House, and was it ever taken up by the Senate, or did they, or not?
They ever take it up? They never take it up.
Not taken up by the Senate.
Okay. Okay, I yield back.
Gentleman yields back his time. Thank you very much. Gentleman from Alabama. Gentleman does not seek time. Thank you very much. The opportunity for you to come up here is one that I would offer my thanks to you. I know you both had to wait, and I apologize on behalf of the committee, but we actually do get into a good bit of policy on every single issue that comes up here, and as you see, Mr. Chairman, that both you and the ranking member have brought something that is interesting, not just to this committee, but I think members. Every single one of us as members have constituents that want and need housing of their choice, want and need to have an opportunity to be able to afford it. And there's that bumping up against rules and regulations that happens, and some bit of common sense But I thought that the discussion that the gentleman from Georgia had was most interesting about how we really solve it. Where the real problem is, whether you should get the house in the first place if you really can't afford it, and yet the costs that are associated. So I would thank both of you for bringing a very interesting issue to us today. The prior panel that was here on another bill brought up very interesting points that dealt with how we deal with federal government employees. And we do this almost every day at the Rules Committee. And I want to thank you for being a part of what we do. Both of you have to take your time and your interest, and I applaud you both for taking time to be here today to lead that discussion. And if you'll please make sure that you know we've got our awesome stenographer, and she would appreciate anything you brought in writing and leaving it for the compilation of the record today, and thank you very much. This, is there any other member that would seek time? H.R. 1069, Preserving Access to Manufactured Housing Act of 2017.
For amendments or?
Yes,
for
sir.
Yeah, I have an amendment for the bill. Doing that now?
Gentleman's recognized.
Thank you, Mr. Chairman. I have an amendment to H.R. 1699, which is just a sense of Congress amendment. I did support the bill last session. I support the bill again. I think the purpose of the bill is really to help reduce the cost of housing, something that's very important to my constituents. So through this sense of Congress, what I hope to highlight is that manufactured housing, of course, is often located in low-income communities, often rural communities, and these are the kinds of areas that certainly in my district and probably in the districts of others often lack internet connectivity or broadband access. In fact, as of this month, 23 million Americans in rural areas lack access to high-speed internet. And of course, as we know, without fast and affordable internet, there's an expanding disparity between educational opportunities, job and telecommuting opportunities, even the consumer experience. And there's simply too many people being held back from accessing the economic potential, the education, the entertainment of the 21st century. And this amendment would simply articulate the connection between Americans who live in modular homes and those who lack broadband internet connectivity, and underscore the critical nature of broadband access to our economic future. So this sense of Congress states that manufactured housing developments are often located in low-income rural communities, areas that lack broadband connectivity. The amendment says it's critical to maintain our commitment to rural broadband access for low-income and rural Americans. And I hope that our committee will choose to adopt the amendment. And I'll yield for questions.
Thank you very much. Questions from the committee?
Mr. Chairman?
Yes, sir.
I had a question. I have a great satellite company in my district called Viasat that I believe has sold their satellites to a company in Colorado, Wild Blue and now Exceed, which my understanding was covered the entire continental United States, such that every American family now had access through this Colorado-based company. Is the gentleman's understanding different, or you're just saying that satellite internet is either cost prohibitive or doesn't qualify as high-speed internet?
Well, satellite has two disadvantages over cable. I live in an area that has cable internet. Most people who do would tend to use cable for two reasons. On satellite, the download speed is usually high speed, and it's fine. It's really the uplink that's the problem. So you can for instance, often, and I don't know the particulars on this satellite company, you can often stream media, but if you want to upload files to the cloud, video or picture, the uplink speed is much lower. It is also more expensive. So it is an option, obviously. In fact, for many people in rural areas, it's the only option. But it is an inferior option, which is why you would see very little users in areas that have access to cable. That wouldn't be as big a market for a satellite internet company. I'm sure a couple people here or there. But in general, more costly, good downlink, very low-speed uplink.
The improving uplink speed is as we start talking about more infrastructure bills going forward, is
very important.
One of those important components.
Absolutely, because it is. You're absolutely right. What we would care about is our rural communities in particular, including modular communities. We're highlighting that because of this bill, but rural communities in general that need more options to be able to access the internet. Satellite is a very good one, but we need to be able to have better uplink speeds, and more competition will ultimately lead to reduced pricing. In the areas that do have cable, they are overwhelmingly the predominant internet provider.
Thank you, Mr. Chairman. I yield back.
Thank you very much. Further questions? I wanted to ask the gentleman in his performance of working with the parliamentarian, is he aware that this was not considered germane?
Well, I do know that the committee often waives that, and it is simply a sense of Congress. You know, I'm not quite sure, you know, a sense of Congress can be germane to whatever you want to put it to under the jurisdiction of this committee. There's no operational language of this amendment that it's simply a sense of Congress that is related to modular homes, which is why we offered it on this bill.
Thank you very much. In my opinion, we have not done that in quite some time. It is, as Judge Hastings would remember from our conversations that we've had, this is the Rules Committee, and that is within the purview and power of the committee, but we have not done that.
Is there any clarification from the parliamentarian why a sense of Congress that is directly related to the area covered by the bill wouldn't be germane?
I was unaware of it, but asked as I was going through this process. It's my understanding that your staff, in consultation with the parliamentarian, understood that and made decisions in that environment.
Yeah, I mean, you know, you look at the germaneness test, as I said, it's a very simple amendment. It obviously relates to the title and content area of the bill. As a sense of Congress, I would hope there wouldn't be any germaneness issues, which usually relate to operational language of a bill.
I don't know if there were jurisdictional issues with other committees. Seemingly, as I heard you discuss this, it seemed like to me that there probably was a germaneness.
Well, I would,
with other
you know, and I would agree with that if there was some sort of operational language. If it was trying to like install broadband somewhere, it would be under the jurisdiction of Energy and Commerce, it would be a different bill. But it's simply a sense of Congress, which we often see, you know, coming in bills out of committee or added on the floor, and you know, it's not something that operationally would have to go through a different process.
Well, all I'm suggesting to you is the parliamentarian and your staff had evidently delved into these issues of restricting some of the language, perhaps modifying some of the language, perhaps directing some of the language, but that was the ruling of the parliamentarian, not of the Rules Committee, and we have not been trying to engage in that and waiving those parameters.
Do we know when was the last time the committee waived germaneness on an amendment?
I'm advised we have not in this majority done that.
Not in what?
Not in this majority.
Not in this majority. Have never waived germaneness?
Have not never, have not.
Have not, okay. Well, you know, be good first time.
Yeah, as is Judge Hastings' regular prayerful consideration, even when he sees me outside of the committee, Judge Hastings reminds me of these, but I'm trying to provide the gentleman an answer back and let him know that his staff did attempt to work that issue.
Thank you, Mr. Chairman.
Thank you very much. Is there anyone that has any further questions from the gentleman from Colorado? Seeing none, this now closes the hearing portion of H.R. 4182. This now closes the hearing portion of H.R. 1699. Chairman, be in receipt of a motion from the distinguished gentleman from Oklahoma.
Mr. Chairman, I move the committee grant H.R. 4182, the Assuring the Qualified Civil Service Act of 2017, a structured rule. The rule provides 1 hour of general debate equally divided and controlled by the chair and ranking minority member of the Committee on Oversight and Government Reform. The rule waives all points of order against consideration of the bill. The rule provides that the bill shall be considered as read. The rule waives all points of order against provisions in the bill. The rule makes in order only those amendments printed in the Rules Committee report. Each such amendment may be offered only in the order printed in the report, may be offered only by a member designated in the report, shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and unopponent, shall not be subject to amendment, and shall not be subject to a demand for division of the question. The rule waives all points of order against amendments printed in the report. The rule provides one motion to recommit with or without instruction. Section 2 of the rule provides for the consideration of H.R. 1699, the Preserving Access to Manufactured Housing Act of 2017 under a closed rule. The rule provides 1 hour of debate equally divided and controlled by the chair and ranking minority member of the Committee on Financial Affairs. The rules waives all points of order against consideration of the bill. The rule provides that an amendment in the nature of a substitute consisting of the text of Rules Committee Print 115-42 shall be considered as adopted, and the bill as amended shall be considered as read. Rule waives all points of order against provisions in the bill as amended. Finally, the rule provides one motion to recommit with or without instructions.
I thank the gentleman. We've now heard the motion as provided by the gentleman from Oklahoma. I'd like to yield myself just 1 minute. This is one rule, two bills, H.R. 4182, structured rule, 1 hour debate, 4 amendments, MTR. H.R. 1699, preserving access to manufactured housing, closed rule. Both amendments submitted were not germane, 1 hour of debate and an MTR. Is there any discussion or amendment to that, John?
I have an amendment.
Florida,
Mr.
yes,
Chairman.
sir.
Mr. Chairman, I have an amendment to the rule, and I move the committee make an order and give the necessary waiver for my amendment to H.R. 4182, number 4, which would exempt veterans from the 2-year probationary period. And everybody heard my argument and heard me discuss with Mr. Como, who stumbled around trying to give an answer to the question that I put to him. I quite frankly am pleased that the amendment with reference to the Peace Corps and the AmeriCorps are made in order, but I genuinely believe that this one is one that would honor our service persons, and that's why I offer this one now, Mr. Chairman.
Yes, sir. Any discussion from the committee?
Mr. Chairman?
Yes, sir. Gentleman from Georgia.
I know that my friend is stating it true, but I will tell you my experience with my veterans is that they would not be honored by having a lower standard set for them that is set for other folks. Either this is a flawed standard that should be applied to no one, or it is an appropriately high standard that should be applied to everyone. And while I recognize the gentleman's good intentions,
And you buy into the argument that 2-year probationary period is a higher standard?
a higher standard for quality government work, the one that the DOD has adopted, and I don't think it would be fair to suggest the DOD is not concerned about honoring our servicemen and women. Again, I know the amendment is well-intentioned, but I would ask.
And the amendment is germane, and it's one that I think the body would benefit from voting on. I understand your point, and I take it.
My concern is, Mr. Chairman, that it's such a, because we all care so much about our veterans, because we all want to honor our veterans, that this could be one of those amendments on the floor of the House that without more time to talk about it, without more time to deal with it, could confuse.
Well, the whole bill, had we had more time and had we done the study, we would be in a better posture, but let's leave it at that.
I yield back.
Thank you very much. I'd like to add that I agree with you that this will be an interesting discussion, and that I found it most interesting today, not only the gentleman from Oklahoma, the gentleman from Georgia, your comments are most instructive. I had some comments as it related to it also, and believe that it is a question. I viewed it, and I don't know that we view it differently because you sit on this side or we sit on this side. I think we're both after, as Chairman Cole said, a better employee, a better opportunity to make it. And I tended to go back and forth in my mind about the effect of this, not one way or another, but what's going to end up happening. And I hope we get a better employee that's given it 2 years instead of 1, that is making that transition to the marketplace. I see more and more and more young people who didn't get a chance, and I'm not saying I had it great, but getting up, throwing a paper route, getting up, having a summer job, getting up, having to go to work and understanding you got to get to work on time and all those things. And so I think in my mind, you know, and of course, Chairman Cole, I think, clarified a lot of it, but I think this is about trying to get a better employee and give the employee a better shot.
Well,
So
when-
I think it's an interesting viewpoint.
if the chairman would just yield for a moment.
Yes, sir.
I don't think you have to worry about it because it ain't gonna pass the Senate.
That could be, but I thought the debate was still good, if not good topic, a pretty good theater, and I appreciated the way the committee handled this. All right, does the gentleman have nothing further, so we are not pushing right now any vote. So I'm going to now move for approval of the motion from the gentleman from, did you have a motion? You did, oh, that's why I was thinking you did. I didn't know if you were still pressing that over. Okay, yes, sir. So the amendment is on the floor from the gentleman from Florida. Those in favor of the Hastings amendment signify by saying aye. Aye. Those opposed, no. No. Noes have it, noes have it. Any further amendment or discussion? Seeing none, the vote now be on the motion from the gentleman from Oklahoma. Those in favor signify by saying aye. Aye. Those opposed, no. No. The ayes have it, the ayes have it. The gentleman asks for roll call vote. Clerk will poll the committee.
Mr. Cole. Aye. Mr. Cole. Aye. Mr. Woodall. Aye. Mr. Woodall. Aye. Mr. Burgess. Mr. Burgess. Aye. Mr. Collins. Mr. Byrne. Aye. Mr. Byrne. Aye. Mr. Newhouse. Aye. Mr. Newhouse. Aye. Mr. Buck. Ms. Cheney. Ms. Slaughter. Mr. McGovern. No. Mr. McGovern. No. Mr. Hastings. No. Mr. Hastings. No. Mr. Polis. No. Mr. Polis. No. Mr. Chairman.
Aye.
Mr. Chairman. Aye.
Clerk report the total.
6 yeas, 3 nays.
The amendment is not agreed to. Excuse me, the motion is agreed to. Excuse me, the motion is agreed to 6-2. So accordingly, the gentleman from Georgia, Mr. Woodall, will be handling this for Republicans.
And the gentleman from New York, Ms. Slaughter.
Ms. Slaughter will be handling this for Democrats. So, 6-3 was the vote. So Judge Hastings wants to ask his question.
Yep, what are we doing next?
We are not expecting any other meetings this week.
Hey, y'all some good people.
Thank you very much. We've now completed our work.